Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
On today's episode of the NC DWI Guy podcast, we are joined by Ron Shook, a colleague and a friend. Both of us went to, as Ron says, the prestigious and now defunct Charlotte School of Law. I like using that intro whenever anybody asks me what law school that I went to. It's a great sense of humor that Ron has. And Ron is the epitome of a person with a student mindset. Having known Ron for a number of years now, I feel like he attends every CLE that he can on DWI, on immigration, on firearms, with a just attitude of hunger to learn. And that has now translated into Ron kind of going into more of a teacher role. Ron is based, his practice is based in Gastonia. He handles DWI, he handles immigration and some other practice areas as well. In today's episode, Ron is going to be talking with us about how to deliver a closing argument, kind of specifically geared toward a DWI situation, but certainly will touch on other elements of criminal law. Hello, fellow freedom fighters, and welcome to another episode of the podcast. Today, we are joined by Ron Shook, the one and only Ron Shook, who is going to be talking to us about closing arguments. Excited to have the conversation with you, Ron. Thanks very much for coming on.
Thank you.
I think we're kind of just going to talk a little bit about the theory that you have in terms of how to develop a closing, at what point that you kind of start thinking through your closing argument. So yeah, tell us just a little bit about what your specific thought process is when it comes to a jury trial and getting ready to deliver a closing argument.
Sure. So you and I have been practicing about the same amount of time. I think you graduated, what, a couple years ahead of me?
Maybe one or two. Yeah. It
I was 2011.
Yeah, 2009, so 2 years,
yeah.
I guess then.
So it's interesting, the more you practice, the more you sort of learn and develop and realize, all these traditional methods that we learn in law school are not necessarily the best, that don't necessarily resonate with people, right? So the traditional knowledge is like, you summarize the evidence, you ask for the not guilty verdict at the beginning and the end, and, it's really just more storytelling. Like it's more, if you're from Appalachia, which, you're up there in Asheville area, people call it visiting, right? It's like you're visiting with the jury. So you sit down and sometimes, one of the best prosecutors I know, Steve Kaufman, he's with the Western AUSA's office. Steve gives his opening and closing arguments in 3 minutes.
That's awesome. Yeah.
He's guilty. Here's why. End of the story. Find him guilty. So brevity is the soul of wit sometimes, right? But as far as structural, too, I want to mention.
Just to dive in on that point too, in terms of law school, I think it's something that I think maybe we all are very intrigued by. Masters of the closing argument, because it is something that feels a little bit foreign. You never really practice that unless you're on a trial team, which I was not. You never really practice that in law school. I did the appeals work. I was on the moot court and did it, the appellate writing class where you're kind of writing and then maybe having an oral argument or doing that at the end of your first year. But it's very different arguing, like you just said, with that structure to a judge and how you kind of want to present things in terms of this black and white legal issue to a judge versus how you're kind of summarizing the evidence and getting jurors to understand concepts of beyond reasonable doubt and, per se limit and all of these different things that are, again, instead of it being this legal issue, you're trying to kind of communicate it in terms of here's what I want you to think about a little bit. So I think that's part of the reason why, the masters of this stuff are revered as such, because it's kind of like
Teddy's, your Les
Yeah,
Robinsons,
yeah,
those
yeah, yeah.
guys. Right.
Totally.
But you know what those guys have in common? They're storytellers.
Exactly.
I like to tell stories. I tell my kids stories. I tell my friends stories. And, you know, I'm a little bit of a comedian kind of thing going on too. So
Hugely helpful with the jury. It's hugely helpful. I mean, think about the
totally.
vantage point that is, especially when you're up against a very like stone-faced kind of,
Stiff prosecutor.
smug prosecutor that is just, realizing that everything is on his side. You got to find some way to kind of get into the heart of the jurors, and humor is definitely a good one.
Sure. Yeah. Well, you know, my favorite things to do, I nailed this young, so he's like 24 years old, cop, and he's in Randlow, North Carolina, which is about 1 square mile. It's one of the smallest towns around. And I just nailed him so hard. You know, he got up there and he's young. He didn't really know what he was doing. Gave the opinion question. You know, it's my opinion your client's mental and physical faculties were so impaired that he shouldn't have been driving. The source of impairment was alcohol. Very first question on cross. Officer, I'm not going to say his name, but Officer so-and-so, what's a faculty? Silence. 20 seconds. He puts his head in his hands and he says, I don't really know, sir. And I said, well, how can you say my client's faculties were impaired if you don't know what a faculty is? And he said, that's just what they tell me to say, sir. The prosecutor, case dismissed, end of story. You know, the testimony was bad on top of it. But those are the moments where we have fun, you know, and
what a great way to think through that ridiculous question, you know, because there's so many officers that you can just tell have no idea what they're saying because they're like bumbling through it. It's like, I formed the opinion that the person's mental and or physical both or faculties are upside down impaired. You know, just you clearly don't have a grasp on what it is that you're expected to say in this particular situation. So that's awesome. I love that question.
A lot of what I draw on with closing and talking and storytelling is, of course, you know, the classic like Aesop's fables. You know, when you're watching a movie, think about how these typical themes, you can apply them to your case, right? Your guy's usually the bad guy in the story. And so what are some cases of stories where we root for the bad guy or you know, how many stories are nobody's really the good guy? Look at Game of Thrones, George R. Martin's Game of Thrones, right? All the characters are more or less flawed human beings. But we still root for some of them. So how do we convince a jury to do that? There's a great website. I think it's either tvtropes.com or tvtropes.org, TROPES. And if you're looking for a particular story in movies or television that sort of meets the theme of what you're trying to go for, you can kind of sort of backwards work through that website. So like I'm looking for a story about XYZ. And it brings up episodes of, you know, Andy Griffith or whatever that you can talk about with your jury that they're going to know. That is great.
That's a great resource. Yeah, I think that it's so important to kind of bring that into the juror's life. There's kind of two examples that I can think of, one that I've used and one that I'm kind of like working through for future cases on. But a couple of years back, I think it was 2018. The solar eclipse happened. And so I had a case that was in the summer, kind of in the midst of that going on. I think that the solar eclipse had kind of like happened 2 or 3 days earlier. So I like got these, you know, styrofoam balls, painted one the moon, the other the sun. And I was like, you know, the moon can pretty much be like almost covering the entire sun, but there might just be that sliver that is like sticking out from the sun. If that sliver is there,
that's your reasonable doubt.
That's your reasonable doubt. Like it's got to be a total eclipse in order for there to be the proof necessary. And I think there's a good, example that you could point to with COVID to jurors as well, in terms of, you know, you don't know that somebody else has the virus. You don't know that you do, but you're basically just trying to do everything that you can to kind of take preventative measures in terms of, you know, this, you know, again, likely if you sit down with another person in a small space, the likelihood that one of the two of you is sick with COVID may be very highly unlikely, but you're going to take every precaution necessary to kind of make sure that, you don't leave any doubt as to that. Right. So I
It's
think
like David Ball's the Tylenol example. Are you familiar with that?
Yeah.
So here's
yeah.
a bottle of 1,000 Tylenol. There's one poison pill. Would you give your family member one of these pills? No. Okay. Well, now the bottle's 10,000 pills. Would you give it to them?
Right.
Yeah, totally.
Right. Yeah. And Lance actually used that in an interesting way, again, around Halloween, kind of took that example to candy. Like if your kid had a huge bag of candy and you knew that one of those was poison, would you basically like let the kid at random draw out a couple of pieces of candy thinking, well, it's unlikely that that's the poison candy? No, of course not. Like you'd check every single piece of candy. And if there was any doubt as to like any single piece of candy, you just get rid of all of it because the consequences are too high. Yeah. So I think that those kind of security type situations that you can put the juror in are hugely helpful in terms of bringing that out. So yeah, I love that.
It's funny you brought up COVID and masks because I've been working on this, man, and I'm waiting. I can't wait for a DWI jury trial. So get this, right? So a lot of what we do sometimes is, who's really the bad guy here? And right, I'm in Gastonia County, which is a very law enforcement friendly, back the blue kind of area, right? And so you never want to speak poorly about an officer. You got to be careful about challenging them.
I've had that go sideways several times.
So David Bow actually helped me with this, right? So how do you fight that, right? And I'm telling this story because I'm going to apply it to what I'm going to tell you in a minute. But so David says, well, you need a bigger bad guy, right? So in Gastonia County, what do people hate more than they hate bad cops? The government, right? So
there you go. That's
we
great.
all love Trooper so-and-so, Judge. We're not asking you to say you did anything wrong. We're just telling you that the government didn't give him the resources to do his job properly, right? So I'm kind of modifying that argument. I can't wait, right? So
that's great.
Everybody's furious about having to wear masks in my area. I'm in a very conservative town, right? Nobody wants to wear masks, and it's individual liberty and things like that. So I want to modify that, and I want to make the masks the bad guy, right? So I want to argue to the jury. Now, members of the jury, got this supposed virus running around, and they've got us all wearing these masks. Now, you heard the officer say that the man had a mask on before and after he blew into the machine. Now, reasonable doubt, you can't say what goes on under that mask. We don't know. Scientists tell you, we don't know. Did it increase his BAC? And, oh, God, make the mask the bad guy. Give him a reason to acquit.
That's a great strategy. I love that. I love that. Like you're just sitting there breathing all of your own fumes back in and out.
Yeah,
like how is this impact?
That's right. That mask was soaked with alcohol. I don't know. We'll see how it goes. Feel free to give that a try.
That is a great one. I think that especially depending on your district that could be a really powerful argument.
For sure. So that kind of brings us to something interesting too, like your Eclipse example. So another challenge obviously we run into is what will your judges let you do, right? Because you can't interject self into closing. You can't reference the Bible and things like that, right? So Joel Harbinson is a really smart lawyer. I think he's in the Mooresville area or something like that. And Joel taught this at a CLE, and I thought this was clever as can be, right? So he likes to use, I'm going to pull this up. He likes to use, in cases where it's obvious a state witness has lied, he likes to quote Luke 16:10, which I'm going to talk to you about that in a minute. But to the theme of not being able to quote the Bible, well, the prosecutors can't get away with it. We can, and here's how you do it, okay? You don't say, Jesus said X, Y, Z. You say, there was once a Middle Eastern philosopher that had a wide following. He was a wise man, and here's what he said. And so here's what this Middle Eastern philosopher had to say in Luke 16:10. He that is faithful and that which is least faithful also in much, and he that is unjust in the least is unjust also in much. So what does that mean, folks? Well, folks that you can trust in little things, you can trust them in big, important things. But if somebody's going to be dishonest and lie in little things, well, they're going to be dishonest to you in important matters too. Joel uses that in rape cases and other really high-profile big emotion, and it's brilliant, right?
It
Because
is
it
brilliant.
says,
Yeah.
if this witness will lie to you about something small, and you can show him, remember when he lied to you about the car was red when we know it's blue? Here's the picture of the blue car. Or she told you that she was raped at 12:10 when we know for a fact the defendant was at work because we've showed you his time card and had a witness show that, right? So she'll lie to you about something small. What else is she lying to you about?
Yeah,
If
that's
this
a
police
great.
officer will lie to you about the speed or red and glassy eyes when you can see clearly on the video that his eyes weren't red and glassy or that he did the HDN properly, what else is he lying to you about? What else is he misleading you about? So anyway, I think that's brilliant. And
No,
I
that
like
is
that.
brilliant. Yeah, and I love that introduction too. That's that
Joel
wise
Harbison, that's
Middle Eastern philosopher.
yeah, that's him.
Yeah, I guess kind of along that same lines, when you are kind of preparing your closing, do you have like a go-to theme, or is it always something that you kind of maybe use that like storytelling tool or whatnot to kind of address the specific facts? Do you have like a kind of a general theme that you always operate off of on DWI cases?
Not really, man, because we try so few cases now
Yeah, that's
in front
true.
of a jury. Only marginal cases go to trial.
Yeah.
And I don't know that there's a Band-Aid. There's not a one-size-fits-all. It's too much fun, frankly, to come up with and apply different things. There's some stories I like to tell too. I told you that biblical thing. There's some things that David Teddy really uses. I think it's Nathaniel Hawthorne. There's a quote that he uses. The power of one is a majority, right? So you're trying to argue for a hung jury.
Right.
You're trying to argue for juror independence. I like to tell the story of William Penn. William Penn was a Quaker. He's the one that the state of Pennsylvania is named after. And I like to bring in, the oatmeal. He's on the oatmeal box,
awesome.
right? So
Yeah,
the jurors don't know that they know William Penn, but they do. So when you're talking about, you're sort of arguing. Oh God, what's the term I'm looking for? Not a hung jury, but
I know what
it's escaping me. Nullification, jury nullification.
Jury nullification.
So we can't argue nullification, right? But we can kind of try to hang the jury by saying, well, look, just because all these other people believe that he's guilty and you don't go along with them. And this is how you do it. So the William Penn story, long story short, I tell this story, but talk about William Penn. He was put in jail by the government. The judge said, the jury comes back not guilty. The judge says to the jurors, no, you go back in there and you find him guilty and you're going to sit there without food and water until you do. 3 times they came back and found him not guilty. The judge threatened him, he fined him, he locked him up, and they continue to return a verdict of not guilty. And that sort of empowers the jury when you're saying, look, I don't care if all 11 other folks think he's guilty. If you think that he's not, you stick to your convictions.
Yeah.
This judge can't tell you how to vote, and these other jurors can't tell you how to vote. So that's a good closing argument sort of story that I like to tell.
That I've not heard before. I've never really actually heard, until you said that just now, a good jury nullification argument. And I think, in my voir dire questions, I'll spend a lot of time asking, if you're sitting in a room, how much is peer pressure going to play into this? If all other 11 jurors are looking at you and waiting on you to kind of join the team, like, how strong do you think you can be in that situation if you really believe the opposite verdict and trying to kind of pull it out that way. But in terms of a direct nullification argument, that is a really powerful way of doing that.
And judge gets on you. Hey, judge, I'm just telling a story. I'm a fan of history.
Right.
A lot of judges miss the lost art of trying a case, right? They love because their peers were the great storytellers, right?
That's
a lot of our judges are of that generation. So I think a lot of them are inclined to sort of let you have some leeway with storytelling and history lessons and things like that.
Yeah, I think the other thing, and this again is maybe jurisdiction dependent, but I feel like there are, especially on DWI cases, younger prosecutors who are so worried about saying the wrong thing or making the wrong move because this is, they just don't have that much, jury experiences. Again, that's not true in every district. Some places, it's the same attorney that does everything at district court that's also in superior and smaller districts, or maybe they've got, especially assigned prosecutor. But in a lot of districts, the new guy in superior court is the one doing all the misdemeanor appeals. And so they're worried about all of the problems that they are going to walk on. So objecting to your closing argument in basically the final moments of the case, they're just like kind of breathing a sigh of relief at that point. It's like, I made it without getting disbarred, So I think you can push the envelope depending on who's trying the case on the other side.
For sure. Yeah. I know, we're sort of basing this conversation on a talk that I gave back in January. And truly, talk about standing on the shoulders of giants. I love just going and watching like a David Teddy, or going and watching some of these guys. And you can steal their material and they don't mind, but David tells a lot of good stories in closing. And I like history and I like telling these stories. So, one of the stories that David tells that I think works really well too, if you have sort of we have officers that maybe add a little detail or test a lie, that sort of thing. David talks about the origins of a brand in the hand. Do you know about the brand in the hand? So this is the origins of why we raise our hand when we swear an oath before we testify. Do you know why we do that? So here's why we do that, okay? So in 17th century London, there were no formal registries of criminal history and things like that. Judges didn't know if a person was truthful or would lie. So one of the punishments that judges could levy back in that day was, and they'd apply an alphanumerical letter to your crime. So if you were a murderer, they'd brand an M in your hand, so that when you raised your hand, they would see an M, and that man's a murderer, we can't trust him. A thief would get a T. A perjurer would get a P. So that's why we do this. And so then David says, ladies and gentlemen, I wouldn't call anybody in the courtroom a liar, but if that man had a brand in his hand, or if that man was testifying in court, he'd have a brand in his hand. That's the story that David tells. I like that.
That's cool. Yeah, that's a great one.
David talks about the origins of reasonable doubt. This was to give the clergy sort of plausible deniability for wrongful convictions. He talks about that. So anyway, I like those kind of stories.
Yeah, I think that's really an important one, because reasonable doubt is so difficult to wrap your brain around if you're not kind of an attorney. Like I think that's one of the reasons why specifically the prosecution is typically so quick to strike any attorneys from their potential jury pool, because if there's anybody that understands what reasonable doubt means, it's like the one thing that we have going on. Literally like the one thing that we have going on our side.
Sorry, I wasn't trusting you, my assistant. Sorry about that.
You realized what I was about to say was going to go the wrong direction there. But no, it's definitely one of the few things that's on the defense side. So if you can really bring that standard to life, then you just got a total different, jury that is able to really kind of return that verdict of not guilty. When you, I guess kind of going back to the preparation standpoint, do you kind of have a theme to your case before you begin the jury trial? So in terms of when you're going to start building your voir dire, building your opening statement, and obviously kind of down the road trying to forecast what you're going to say in closing, do you try to develop a theme specific to the case, or how do you kind of operate? I've mostly gone off of a pretty formulaic kind of voir dire, opening statement, evidence, closing statement. There's a lot of like kind of formula to how I do it. And I really don't think that that's best practice. I think that is again, the best jury trial lawyers, I think, really kind of do what you're talking about, which is kind of telling a story. And if you're a great storyteller, then you have a great chance with a jury. But yeah, tell me a little bit about your kind of whether or not you use a theme.
Sure. Yeah. The way that you try a case is the responsible way to try a case, right? I certainly wouldn't want any client to think, well, hell, this guy's just coming in here and winging it, So, yeah, surely I have, an overall idea of how I want to explain a case to a jury, but sometimes inspiration strikes you in the moment, right? So, we got that very formulaic education in law school about, you ask for a not guilty verdict, and then you talk about the facts of the case, and then you explain reasonable doubt, what that is, and then you ask for the not guilty verdict again. I'm moving away from that. I'll tell you some resources I've been using. Am I allowed to show specific brand names and things like that?
Yeah. No, I mean,
I didn't know.
And again, I think that the, just for everybody that's on the, in the audience, the CLE that you were referencing was a North Carolina Advocates for Justice CLE from February 2020, correct? Was it January or February?
I believe it was the end of January. Yeah.
Okay.
Maybe.
Yeah. So you can go back and watch that on the NCAJ website and kind of get some more of this material. But no, yeah, fire away in terms of any of these resources.
Yeah. So this is well, it's inverted, but David Ball on criminal defense. They lay out a whole case. Great book. They lay out a whole case approach to from applying your theme from start to finish and recapturing reasonable doubt. What is reasonable doubt? All of my cases now, reasonable doubt is the strongest tool in our toolbox.
It is.
And, hey, we ain't got to prove crap. Right? I can sit there and not say a word. Sometimes, you know this, when you cross-examine, okay, so the prosecutor gives this searing direct examination, they think, and they go over to you and you're unimpressed. And the most powerful thing you can say sometimes is, no questions, no need. Counsel, any questions? No need. That kind of thing. Yeah, make them prove the case. So anyway, that's what David Ball's thing is. I say him, but he and Don Keenan and some of these other folks, they talk about recapturing reasonable doubt from voir dire through opening, your cross, your closing, everything is through the lens of reasonable doubt. And what does that mean? So your questions in voir dire, as you were saying, what does it mean? And have you ever experienced reasonable doubts in your life and things like that? So yeah, that's a good resource. Another thing I found, I like this. Now this isn't a practice manual, but it's some sample closings, and again, it's inverted, but it's kick-ass closings.
That's awesome.
The author is Michael Waddington, and this is literally just closing arguments that he's given in different situations or other lawyers have given in different situations.
That is a great resource right there.
It is, because what you can do, okay, so say, hey, my theme or theory of this case is that the witness is a liar, right? She says she's been raped and she hasn't. I've been preparing a rape case, by the way, which is why I keep talking about that.
No, that's good.
You practice, you know how it is. You sort of get desensitized. But so say that's the theory of my case is the witness is a liar. So he gives, witnesses, liars, and then there's a closing that applies to that case. So
that's great.
That's a cool resource. Yeah. He talks in there about redefining reasonable doubt and how to explain it and things like that. So that's a good resource too that I use.
Yeah, no, that's really powerful. I think that, I think just having that operation for those of us, and I like telling stories, but definitely that skill is developing for me. It's not a natural skill like it is for you're definitely a natural storyteller. We both know, Chaz Post, he to me is a very natural storyteller as well. To me, I'm really having to kind of work at that craft and try to build that.
You're more of what we call a mechanic or a technician,
right? Exactly.
Right? You're very methodical. You hit all the bullet points, but there's benefits to both, right?
There's benefits to both. Yeah.
Sometimes I close and I'm like, crap, I completely forgot to talk about, XYZ, right? You never miss anything.
Yeah,
so that's the advantage.
There's definitely advantages to both sides, but I think that for those of us that aren't those kind of naturally gifted storytellers, just having, the ability to kind of find something like that and then use it to rehearse the story a little bit, kind of work through that, because jurors need the story. I think that it's really difficult to get them to return a not guilty if they don't believe in the story, right? They don't care about the facts, so to speak. They don't care about the law. They care about the story. And like, does this person deserve to get off because of these different reasons, or do they not? Like that. It's all
My
in the
God,
story.
trying to explain to them, blood testing and conversion rates,
yeah.
and no, they don't care about that
No,
crap. No. All right, members of the jury, here's what you got. You got this lady who did a 2-week phlebotomy degree, okay, and there's a box with a computer in it, and she puts this guy's blood in a box, and she pushes the buttons in the order that they tell her to, and a number comes out the end, and she takes that number and she tells you that means my client's drunk.
Yeah. That's it.
If you got a problem with anything that happened in that box, or that you don't trust it, you find him not guilty. That's how you tell that story. This was a plasma sample. When they converted the whole blood, they used a 1.16 conversion ratio instead of 1.18. And they're like, what the fuck is this guy talking about? Sorry. No, they don't care about that. That's how you tell that story. There's a box. They put the blood in it, and the box tells you that he's drunk.
Yeah,
right.
You're
right. I'm agreeing with you, but
that's so true. I think that is a really important thing to understand when you kind of, again, know the audience that you're going to be talking to. I think a lot of prosecutors, but maybe equally as many defense attorneys, really don't understand that they're speaking to who they're speaking to, who the audience is that they're speaking to. You get so used to doing things a certain way in district court, and here's the different motions and things that I have to file. And then you forget how different a beast a jury trial is. I mean, it is the Wild West in front of a jury, and you can forget about that, because especially if you're trying the same type of cases all the time, it's kind of like, well, I know what my jurors are going to be thinking. It's like, no, these are 12 new people. You have no idea what these people are going to be thinking.
So there's a legendary lawyer, and not a lot of people know him outside of my town, but in Gastonia, Jim Funderburk. And Jim's old school. And Jim won a DWI one time. His guy was guilty as sin. He was drunk. He blew like a 23. But here's what happened. So his guy was drunk. He leaves the bar and he's like, crap, I'm drunk. He pulls over. He starts to sleep it off. We see this all the time, right?
Yep.
The guy's asleep behind the wheel. Or in this case, in Jim's client's case, he pulled off in a parking lot. He wasn't bothering anybody. Okay. And he's sleeping. He's got, I think the car was running, but he was cold. Okay. It was winter. And Jim got up there and said to the jury, yeah, he was drunk, but he did what we want him to do. He didn't try to drive home. He realized he was drunk and he got up here and told you that. I realized I was drunk. I pulled my car over so I could sober up. Members of the jury, he did the right thing, and you need to reward him for that and find him not guilty. And they did.
There's a jury nullification argument right there. That's
they found him not guilty. I said, you're right. That's what he was supposed to do. We don't want him to drive home.
And that the vast majority of people buy into that, right? Like it's the same thing with those bicycle cases or other things where even the prosecutor's like, this probably shouldn't be illegal, but it is.
Trying to keep a straight face. He was riding his horse.
Craziness.
Get a DWI on a horse. The horse is in charge, not you.
Yeah,
as long as the horse isn't drunk, you should be not guilty.
Yeah, there you go. You got to watch what your horse is intaking there. So, well, I think maybe this would be a good place to finish. Is there anything that you have seen kind of either yourself made or prosecutor or another defense attorney where they've kind of made a mistake in terms of closing, and it's kind of like, wow, really good lesson to learn? Because I think a lot of times it's a lot easier to learn from the things that we've done poorly than the things that maybe you've done extremely well. Again, with the storytelling thing, it's kind of like, I can keep practicing this, but the natural storyteller is not going to come out. It's a developing skill. But on the flip side, what things have you seen that lawyers have done poorly that is a no for closing?
Your associate Lance Williams is great. He tried a case against a prosecutor here in Gaston County. Lance did a great job. It was the prosecutor that didn't do a good job. He was extremely robotic. Didn't listen to interact or make eye contact with his jury. Lance's client was guilty. and he should have been found guilty, but he wasn't. Lance got a not guilty because this prosecutor was so wooden. The jury hated him. In voir dire, this is funny, and Lance could tell you about this. So in voir dire, the prosecutor is going down his line of questions. He's not listening to the answers, right? And we're taught voir dire is not about making yourself look good or covering your bed. Listen to what these people are telling you. And he says, has anybody here ever been a victim of crime? The lady raises her hand and says, okay, ma'am, what was the crime? Well, my husband, I was a victim of attempted murder. Oh, attempted murder. Now, was he successful?
That's awesome.
Ask Lance Williams about that. And the lady said, if he was, I wouldn't be sitting here, dummy. And he lost that. I think that's when he lost that case.
Yeah, that's so true. I mean, I think as soon as you make the jury feel unimportant, you've lost them. I mean, everybody kind of, they're taking their time away from their family, their job to be sitting in this courtroom. As soon as you kind of tell them that their time is being wasted, it's like game over. I mean, that's
you show them you're not listening to them. That's right. Yeah. So certainly, in Gaston County where I am, it's pretty country. Don't use Latin. Don't use big words. If you use Latin, you need to mispronounce it intentionally. Don't call it voir dire, call it voir dire.
Yeah. That's awesome. Yeah, that's awesome. Yeah, I think that just to echo that, I think that anytime that you start hearing a lot of that legalese in the closing argument, again, you're just losing people, talking over people, as opposed to kind of making those stories like you said about the lab technician and the little black cardboard box. It's like, well, that's the way that you communicate about these kind of things, because everybody really does want to, I think most jurors want to make a good decision. They do care about it. If you do a good job in voir dire, you get rid of the people that don't want to spend their time in there for the next couple of days, listening to the evidence. The people that are in the box are in there invested. A lot of people actually even enjoy kind of going through the jury process. So I think
especially during COVID when they're risking their health to be there.
Yeah, exactly. Yeah. It's finding those people that are interested. And so really making sure that you're giving them the right information to make that decision. And again, storytelling is the key to that, I think, because it's all about, what's the end outcome that we're looking here, right there, the moral of the story. Well, if the story doesn't have a moral, it's a sucky story. It's a terrible,
or an ending. Yeah.
Or an ending. It's just not a good story. So being able to provide them with that moral framework of here's why we're moving in this direction and why a not guilty is the appropriate outcome. You can't do that without a story.
Well, and to your point about, mistakes lawyers make, I think the number one mistake that lawyers make in closing and just in trial in general is don't make it about you because of insecurity, right? I mean, there is some insecurity. This is a scary thing to get in front of all these people with somebody who may or may not probably is guilty or did something bad. And so through insecurity, you want to be the smartest guy in the room and you want to show everybody you're the smartest guy in the room. You don't need to be the smartest guy in the room. You're going to hurt yourself. And that arrogance leads to losing the jury and the judge and other folks. So yeah, you're dead on. Man,
that's cool. That's a cool thought. I like that. Well, Ron, I appreciate very much all of the insights and thoughts. We were talking about this before the podcast, but we'll have to have you back on here in a couple of months to give us some firearms information here.
Yeah, I'd love that. Thank you.
Definitely. Thanks very much, Ron. Hope you have a good one.
Bye, buddy. See ya.
Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.